Hello, everyone. This is the Injured Workers Legal Side podcast with Richard and Paul.
You're Richard. You keep forgetting that. And I'm Paul. I'm a licensed paralegal by the Law Society of Ontario. I work in workers' compensation law, human rights law, and many other areas. If you want to reach out to either one of us or be part of this podcast as a special guest, and we've had quite a few, you can reach us on the links below. This week's topic is a dual topic because an interesting thing came up and we're trying to squeeze in a second topic, and it's my fault, so I do apologize. The first topic is following the advice of family doctors who treat injured workers, and the second one is the doctrine of public trust and the WSIB. Richard, take it away with the doctors topic.
Thanks. So, in today's medical environment, to see a specialist can take anywhere from 3 to 6 months. And historically and currently, if you're telling the WSIB that my back is bothering me too much to do any work, or my shoulder is bothering me too much because I'm in extreme pain, the family doctor will often write a note or do a functional abilities form saying the worker should be off work indefinitely or at least for a few weeks. And the WSIB routinely rejects those reports from the family doctor. And then what you see is decisions from the appeals tribunal, which is the final level of appeal, which rules on whether the worker should be paid for 2 to 4 weeks of being off work when the employer is inviting the worker back to modified work. So I'd like to spend a couple minutes addressing this issue with a few of the decisions. So in one decision, number 1497/23, the family doctor said the worker has so much pain they can't work. And the employer was saying, come back, we'll give you some desk work to do and a bit of cleaning, and we'll make sure that it's not too hard on your two shoulders, which were injured. You can work at waist level and not have to lift anything. And the WSIB refused to pay the worker for the 3 weeks, and they ended up at the tribunal. And the tribunal's ruling is where the family doctor's advice is reasonable, follow the family doctor. So this is a decision that's clearly at odds with the board's policy.
What's reasonable, Richard, when you say that? Like, if I may, my understanding of evidence, just starting to learn the law, is that there's two types of witnesses, I should say, in a legal proceeding, as an expert witness and a lay witness, a lay person, which would be generally like when it comes to medical stuff, it'd be anybody that's not a doctor. And in that situation, the difference between the two is that a lay person can only testify or report about what they heard, saw, and I think that's it, right? Whereas with an expert can actually give an opinion. And further is there's two terms that I know, which is objective evidence and subjective. Objective is like how I compare it is the weather outside is subjective would be, man, it's hot out. And then objective would be, it's 30 degrees Celsius outside. So I've noticed in mine in decisions is that the board will say we demand objective evidence from the doctor, but the doctor themselves, if I'm not mistaken, Richard, is an expert. So their opinion in examining you and everything else is weighed heavy or should be in the law to say, well, they are an expert. Now, if the board or anybody wants to challenge them being an expert, they have that right, but they shouldn't, in my view, dismiss them. You know what I mean? Am I right in saying that, Richard?
Oh, yes, because what the WSIB is saying is we don't have any evidence the worker can go back to work for the first few weeks. We have evidence that they can't from the family doctor. The family doctor has some expertise in what a disability is on a medical basis. And given the evidence all tilts one way, they should be listening to the family doctor. Now, if the worker, for instance, this sprain was extremely minor. In other words, they felt a little pain for, half an hour or something, and then they say, well, I don't want to do this again. I'm not coming back to work. You could see that the family doctor telling them stay off work for 3 weeks would just be flat unreasonable. But if the family doctor is of the view that they've sprained tendons in their shoulder, some people can have significant pain. Then go to the specialist. Let's say you get to the specialist within 4 weeks, which in Ontario today would be a miracle. And the specialist diagnose you as having some minor tearing in your rotator cuff. Can the specialist then say you're in too much pain or you're not in too much pain? What the specialist essentially can say is with some partially torn rotator cuff, you should be able to do some work, but how much pain you're having, it's always subjective.
Yeah, and that's one thing that bothers me too on a side note, is if the board's demanding the injured worker go see a specialist before they'll believe anything, is problematic because now you're taking limited valuable health resources away from others that need it when more than likely it wasn't needed. You know what I mean? Like if they were being fair, now you're wasting the resources of these not experts, but specialists.
Let me just throw in three other cases. One is 1254/24, where the family doctor made a diagnosis of a psychiatric disability following a work accident and said the worker should stay off work, and the appeals tribunal accepted it. So this is a doctor obviously going into a subspecialty for which they're not a specialist and saying, yes, the person does have a disability that's affecting their psychiatric condition. A second one was 62324. They relied on both the psychiatrist and the family doctor to say that the worker had a traumatic mental stress episode at work. So they said both are valuable. Um, and the one I mentioned before, 1293/22, the family doctor provided reasoning, and this is answers the question of what's reasonable. The family doctor has to provide some reasoning as to why be off work. So the family doctor can say, I moved his arms. It appears there's some tearing in the shoulder from what I can see, and they should be off work for the time because the initial tearing is going to be very painful.
But what should an injured worker when they get a report from a doctor? Like if they're at the doctor's, so say I'm at the doctor's office, you're my doctor. Oh Lord forbid for you. And you're examining me and you say, Paul, you're off work. Like it's not that I should challenge you, but should I say to you, hey doc, can you put a little bit more detail? Like would that be advisable for the injured
Yes, I
just
think
to avoid it?
an explanation as to why to be off work and
Mhm.
another explanation as to why you can't come in to do light work. In other words, specifically mention it
Like
because
risk of harm or
employers, as we did in our last podcast, which hasn't aired yet,
something.
employers offer modified work on day one and they expect the worker in. And they have a financial reason for that, which is they don't want to pay the costs that the WSIB is paying.
Well, there's also a
Starting on the
legal
first
reason
day.
too. There's a legal reason too, is that employers have to comply with the Human Rights Code,
Right.
right?
So both, the letter from the GP, if it goes into a bit of reasoning and a bit of knowledge as to what's on the table from the employer, would obviously be helpful. But the tragedy of the situation is WSIB historically, and we can't say currently because they're on strike, so who knows what they're doing.
Yeah.
But historically, they just reject these opinions after a day or two.
Yeah, and it's unfortunate because now, again, getting back to the healthcare system, its impact is now the doctors, and I sympathize with the doctors because they're now having to battle with the WSIB just to get um the worker entitled. And it's like workers are almost afraid to say anything to the doctor because they don't want to lose that doctor because that's their family doctor and it's impossible to find one. This
Mm.
is this is a negative impact on injured workers with the healthcare crisis,
All
unfortunately.
right, Paul, you were going to talk about the legal public trust doctrine that came up recently in the Ontario
We,
Place decision. Well, you'll
we
start it off and I'll
yeah,
make
because
comments.
I'm not too well, actually, I have very little knowledge about public trust at all. I just understand a little bit about trust being in the legal profession. Trust is where something is given to you and you hold on to it. You can't use it for yourself, which is a big no-no. But in this situation, there was a case I was reading that there is a term of public trust. And Kendall, who was on before, he had mentioned it as well in relation to workers' compensation because many often call it insurance, but really is it? It's a system developed to provide for workers when they're injured. The board's job is to collect the money and then pay for injured workers. So I would define it, in my opinion, which probably isn't very powerful, but it is a public trust. And then the question then becomes, is there an infringement of the public trust when the board acts arguably um, inappropriately by either, forcing the worker back to work, not giving them benefits, or in alternatively, like they have been doing, is giving these big rebates. One of the concerns I have with the rebate, believe it or not, on the side of the employer, is that if the WSIB was theoretically wrong, if we accept that they were wrong in obtaining their surpluses that they claim to have, what would happen to employers if injured workers were able to get an acknowledgement of that in courts and they won, like, say, a legal suit or something? The WSIB then has to pay, but they then have to get that money from employers. This is why I really emphasize the importance that employers shouldn't be, the system shouldn't be biased one-sided, because it will literally hurt the one that they're helping right now. What
Well,
do you think, Richard?
we had this issue on the age 65 matter where we argued that the WSIB system is not an insurance scheme. It's not like you bought into an insurance scheme that you got from Sun Life and you pay this amount of money and they give you this coverage. The WSIB is a scheme that is supposed to assist injured workers to recover and receive some benefit in lieu of their injury. And in the age 65 scheme, what we we're saying is at that time, about 12 years ago, close to 20% of people are working past 65. When they get injured, they receive very little benefits and assistance. So that rule should be struck as it's not to public domain, public fairness. And the position of the courts were WSIB is an insurance scheme. And if you go, I think Kendall's point was when you go back to the very beginning, it wasn't made as an insurance scheme. It was made as a statutory benefit. So what they're saying in Ontario Place is not a site for the premier of the province to develop it into a resort for wealthy people. It's a public domain, a public park, a public area to enjoy. And it's a breach of the public trust to change it from a public place to a private place. And the court ruled they don't see a statute that says uh, the province is under a public trust for parkland it owns. And they dismissed the case. I think it was at the Court of Appeal. So
Yeah,
they
it
may
was.
well be appealing to Supreme Court of Canada. But one can see that the biggest problem is that the public's interest becomes secondary to the interest of those paying into the plan, or in the case of the province, those who are maintaining the space.
I think that's the key, in my opinion, in when you're defining public trust and insurance and that, because I wouldn't fall into the debate of whether it's insurance or not, because I would look to say, like, I would say the term then becomes arguable, and you can say, well, okay, fine, it's social insurance, right? Whatever. My point is I would say it's public because, unlike many other things, this specific item impacts the greater public. For example, a car accident, if you're injured in a car accident, is uniquely different than a work accident because now the public has to take care. Oh no, that's a weak argument. But do you see what I mean? Like there becomes a point where the public has an impact on it, whereas with any other issue, the public doesn't generally.
Well, I argued a case at the appeals tribunal on Wednesday,
Mhm.
and what the WSIB did is they sent out a private investigator and saw that my client, who was saying that it was impossible for her to work as a teacher was because she has tremendous pain. They said, look, we sent out a private investigator who looked at you for 24 days. And on 7 of those days, you left the house and went driving for about 30 to 40 minutes in total, taking your child to a hockey game.
Oh, no.
And they said, the WSIB said, well, look, if you can drive, once or twice a week to a hockey game, you can go back to work as a teacher.
There's two mistakes with that
Yeah. Well,
point.
my point was good. So tell the worker if you're in good enough shape to get out of the house to go to the hockey game, you're in good enough shape for us to send you to our treatment facility, and we'll have 6 medical specialists work with you over a few months to get you back functional, not just cut you off, wave goodbye, and see you later. Because the system should be one where you're trying to help the person. You don't want the person cheating on your system, but you're trying to help them.
Exactly.
Instead, the purpose is when can we cut them off and how fast can we do them? So it's
It,
that was the point I made. It'll be interesting what the appeals tribunal does with it.
but see, the concern I have with that is, and correct me if I'm wrong in that situation, you have the observer who's the private investigator, and then you have the case manager, then the appeals officer, and now the panel deciding in what they observe as to being medically suitable, meaning the worker can do this. And there in itself, right there is the flaw. As in Fiera, it clearly stated they're not doctors. They can only weigh medical evidence, they can't make it up. And more importantly, the exact same case was R.V. Curtis, where it went to the Court of Appeal, and the judges said that. See, the mistake I found with that, because I was there observing, and the problem I had with it, Richard, well, I mean, they go to the very minimum, which was, did the WSIB in prosecuting the three injured workers meet the mental intent, the mens rea? But I was like, no, I think more specifically, I would have looked at, I found I had David Curtis's case and his transcript, but I couldn't find the other ones because, well, in provincial defenseless court, no written decisions are made or anything else, so it's very hard to ascertain. But in David's case, there was no doctor reviewing, like even if at the very least the WSIB had sent it to a medical consultant and said, from my observations in the video and everything, the guy's fine. Because that I found in case law, I don't like it, but it would be kind of when, see, that's the thing is that you're basically saying, in my observations, I think you're medically fine. And I'm not okay with that.
Well, that was the case. There were medical specialists from the worker saw all saying the worker remained extremely disabled. The employer got a medical opinion 8 years later saying from the video the worker should be able to start doing some schooling or teaching. So the employer, obviously spent the energy seeing your problem and got their own medical reporting. But it's a difficult case. People just have breakdowns. The worker's accident in this case was she got hit by a 5-pound block in the head by one of her students and got a traumatic brain injury. But people just she worked steadily for 30 years and then she has this breakdown and she needs help to get back to her life
But
and
if I
not
may,
not being cut off.
taking a child to school, is it not different mentally, cognitively than teaching, say, maybe grade 12 calculus?
Yes, it is. Well, she's teaching
Okay.
in grade school and grade three, but it certainly is a lot less stressful taking your son to a rink so he can play hockey and
Well,
taking
grade
him
three.
home for a total trip of 30 minutes both ways
Richard,
than
I
it
would
is
say even,
teaching.
yeah, I would say grade three is even difficult because remember the big joke, are you smarter than a fifth grader? And many people fail. So
All
I'd
right.
say even grade three.
So we'll leave it there for today, and
Yeah.
we welcome everyone to watch us again next week. Thanks.
Bye for now. See you next week, everybody.